The topic of this session today is European Directives. Before I introduce our excellent panel of speakers, I'd like to briefly mention about our network who organizes the Law and Policy webinars. And let me share my screen for this. The Urban Governance Research Network is an academic platform for researchers to share, co-produce, and co-create knowledge on the topic of urban governance. The platform was initiated by Professor Tonata Kok, who is Professor of Urban Governance and Planning at the University of Amsterdam. The main aim of UGoveRN is to connect academics, practitioners, and communities who work in the fields of urban governance to create an interactive platform to discuss and collaborate on research projects and initiatives. Besides law and policy, our network works in two other research teams, which are planning and property and space and society. And I apologize, I started with the wrong slide. Today, yes. And today we will talk about European directives with 4 amazing speakers. And I apologize in advance if I mispronounce any Dutch names, which are a bit unfamiliar to me. And Saskia Lavrijssen, Martijn Groenleer, Pauline Westerman, and Tobias Arnoldussen. We will try to address how European directives translate into local laws and policies, and whether they provide support for local and environmental issues. We will have 3 presentations that will touch on these questions, each 12 minutes long, which will be followed by a discussion led by Tobias. Let me briefly mention about some housekeeping rules. The session is recorded and we are asking the audience to remain muted, but please do not hesitate to submit any questions anytime in the chat box and engage in the discussions in the Q&A. After each presentation, we will check whether there are any other questions. In case there is not any other question, we will move on to the next presentation. After the presentation, Tobias Arnoldussen, our discussant, will have the floor to weave together the presentation and ask a few questions to the presenter. Then we will have a lively discussion, but for now, I would like to invite Professor Saskia Lavrijssen for the first presentation. She's a Professor of Economic Regulation and Market Governance at Tilburg University. So right now I'm sharing my screen. And Saskia, the floor is yours.
Yes, thank you. I will share the screen. Can you please allow me to share the screen?
I guess now you're
okay. Yes, now it's okay. So you can see it all? Okay. Well, in my thanks for having me here, and very nice project that you are conducting. No, I'm Saskia Lavrijssen, I'm Professor of Regulation and Governance at Tilburg University, and I'm specifically working on the energy transition and the regulation of the energy transition. I'm also part of the Longa Via team, which is a research team that is being funded by the Responsive Innovations Program of NWO, and there we conduct research into the regulation and governance of the network sectors. And it is also in the context of this project that I had been asked by people from that program of the Responsive Innovations Program and the Next Generations Infrastructures Foundation to conduct a research into the question whether the metro of Rotterdam, the RET, can become an energy company. And specifically, they wanted to know what are the legal conditions to transform the metro into an energy hub. Well, and a lot of EU law questions were related to that. But I will first explain what was at hand here. in the city of Rotterdam, like also in the city of Amsterdam, there's a lot of network congestion, meaning that the distribution network does not have sufficient capacity to connect new renewable energy projects or electric charging units for public transport buses to the grid. And that means there is a lack of capacity, and this can really frustrate the completion of the sustainability goals of the climate accord, but also the local goals of communities that want to increase renewable energy and also stimulate the electrification of public transport and of city logistics. So that is a problem. So you see that communities, but also public transport companies and businesses are thinking of new ways of using networks of flexible means of making better use of the networks that are in the city. And also the RET, the metro, has an own electricity network to feed the metro system. And this metro electricity network is connected to the public distribution grid of Stedin. This is the distribution network operator of the grid in the area of Rotterdam. And the RET had the idea that it could use its own network much more efficiently and optimally as a local energy grid. And therefore it proposed that it will act as a hub in which it also is able to sell the capacity in its network and also the excess of energy that is in its network that it doesn't use, to sell it to other companies, related companies like the operator of the public buses, but also to possibly interested third parties so that they can use the capacity of the grid that is not used by the metro itself, and also the excess of energy. And therefore it's interesting to know that when the metro breaks and it has to stop, a lot of energy is generated. So there's times in the metro network a lot of excess of energy, and they want to use that energy more flexibly. That what the metro wants is actually in line with the developments at the EU and national level, is that local grids are used in a more optimal way, and that if they don't need certain energy and capacity, that they can sell it to flexibility markets, and there the DSOs, the public operators, can buy excess of energy to keep their own electricity grids in balance, because energy demand and supply should always be in balance in the distribution grids. Otherwise, there will be problems with the safety of the grid. So that plan to make the metro a hub, it actually fits with the tendency to make more use of energy networks in a more flexible way. However, the big question was, is this allowed? And a lot of rules here are applicable. We have the European Railway Directive, we have competition law, and we have the Recast Electricity Directive. For the purpose of this presentation, we focus on the Electricity Directive, and I can already mention that the European Railway Directives actually do not provide any hurdles for realizing this, because they're not so concerned with local transportation by rails. We have the Electricity Directive, the Recast Electricity Directive, which is part of the clean energy package adopted at the EU level. And this Electricity Directive aims to stimulate the internal energy market, but also to stimulate the integration of renewable energy and electric mobility into the electricity system. And it provides minimum rules, and these rules have to be implemented by the member states in their laws, and they still can go further than the minimum rules in the directive. In the Netherlands, these rules will be translated into the Concept Energy Act, or they are translated in the Draft Energy Act, but this act is still in a preliminary stage, has not been yet submitted to the Council of State, and we are lagging behind because it already had the directive already entered into force. So we will focus on energy law, And one of the most important questions is, if the metro wants to do this, how do we qualify the metro network and the energy hub? Because if the hub is a distribution network in the sense of electricity law, that has quite some implications. We have several lines or installations in energy law, and the installation and the direct line, if the network falls within these categories, hardly any rules are applicable. But the distribution network, then there are a lot of rules are applicable. And when is there a distribution network? That means that if energy is distributed along the medium voltage and low voltage network to transport energy to end users. And this means basically that along this grid, more than one users are connected, and that the energy is transported to them via the grid. And if we look at the business case of and the ideas of the energy hub, we in our research that we did, we concluded that it can be seen as a distribution network along which energy will be distributed to supply several energy users. And that has quite some implications, because if you're a distribution network, then you have to appoint a system operator. And that is a very intensive process, because there's a certification procedure. You have to ask permission at the Ministry of Economic Affairs. That means that you have to comply with several obligations, and also the unbundling obligations. That means is if you're operating a network as a distribution network operator, you're not allowed to have any activities in the supply of energy or in the production of energy. And that also would mean that the hub could not be realized, because in the energy hub, the metro wants to operate the system, but also supply the excess of energy. So this is the basic rule. So there should be an operator, but there are some exemptions that you do not have to appoint a system operator, and that is there if you can be seen as a closed distribution system. And this is also regulated by EU law, Article 38 of the Electricity Directive, and also in the Electricity Act. And closed distribution systems actually are grids, local grids in a geographically defined location to which less than 500 customers are connected. But in principle, no household customers are allowed to be connected to the closed distribution systems. And you can think of closed distribution systems like Schiphol Airport and ProRail, the network of the rail operator. Those are closed distribution grids. If you're a regular distribution network operator, then you have a monopoly to operate the network in the area where your network is, and you have to be unbundled from supply and production activities. However, I just told you, if you can be seen as a closed distribution grid, you can be exempted from certain obligations to which the distribution system operator is subjected. And these conditions are also following from the directive, and they are implemented in EU in the Electricity Act. And the main grounds for exemptions is that the system and the users to it, they are all connected with each other because of technical reasons. So if you look at, for instance, ProRail, ProRail is connected to all the stations that are at the rails that are connected to the rail, and that whole system is seen as one closed distribution system, because the network operation and the way electricity is distributed and the way it's used, that is all seen as one technical system. And the same goes also for Schiphol Airport. And you also have several industrial sites in which there is a closed distribution system. Another reason for exemption is that the network operator of the closed distribution system will mainly supply energy to its own companies or related companies. And related companies are, for instance, companies that are in the same group or that have the same shareholder. And the closed distribution system should supply at least 50% of all energy to its related or own companies. So you see, there are certain possibilities, but there are limits to it. So you cannot do everything there. So for instance, if a closed distribution system wants to cooperate with citizen energy cooperatives within the closed distribution system, that is not allowed, because in principle, households cannot be connected to the grid. So there are limits. Though the closed distribution system is subject to less strict regulatory obligations than a regular public distribution network, but a lot of these obligations should be exempted specifically, explicitly. So in general, also the operator of a closed distribution system should make sure that the system is operated in a reliable and safe way, that there is cooperation with network operators in the area. Furthermore, what's important is that this system is also subjected to third-party access obligations. All networks in the Netherlands, all energy networks, they have an obligation to connect users to the network and to transport energy. So there are certain obligations, and they are also applicable to the closed distribution systems operators. And the aim of that is to ensure that everyone that is connected to the system has a free choice of suppliers. So if you are connected to a closed distribution system and you're not a related company, then you can take the energy from the system, but you also still have the right to buy energy from another company. That is your right based on EU law. And a closed distribution system is not subject to the strict tariff regulations obligations like the public distribution network operator. There is a more light regime. So here are other obligations that can be deviated from, and that is, for instance, a normal public distribution network operator is not allowed to operate and own storage facilities and electric vehicle recharging points. However, EU law allows that the closed distribution system operator also can own and operate electric vehicle recharging points and also storage units. So in sum, the closed distribution system operator is subjected to a less strict regime. So it does not have to assign an own system operator that has to be certified. It does not have to be unbundled, but for the rest, it's still subject to some obligations. However, they can also be exempted from some obligations, and those are also explicitly mentioned in EU law and in national law. So I think that is really a complicated law, and we came to the conclusion that there are quite some possibilities, but there are also clear limits. And for the EOV hub, for the metro, it was important also to know to what extent are the third-party access obligations applicable to the metro network. And there we said that in principle, these third-party access obligations apply. However, there can be exceptions. If there's no sufficient capacity in the network, then the metro can refuse to transport energy, just like regular network operators. So there are possibilities there. But what is less clear is that to what extent should there be a free choice of supplier in this hub? In principle, all users that are connected to a distribution network or to a closed distribution system, they have a free choice of supplier. But if you have this idea of the hub, this may be a problem, because we just said the hub wants to sell the excess of its energy to the third parties that are connected to the grid, so they can use the energy in their hub in a more optimal way. So if that would mean that the most parties that are connected to the grid won't buy the excess of energy of the hub from the hub, this means that the business model of this hub could be frustrated. And EU law is not clear to what extent these hubs should safeguard the free choice of supplier, and whether there are possibilities to give this hub more leeway to limit the free choice of supplier of the parties that are connected to its system. And that is something which has to be elaborated in EU law and also in national law. So the conclusion was that EU law really gives quite some leeway for looking at new innovations that allow to use energy in a more optimal way and energy capacity in a more optimal way at the local level. However, there are also certain restrictions, and the question is, are the exceptions that are already there in the law, are they still sufficient, or do we need more exceptions? For instance, do we also think it would be necessary that energy citizens cooperatives could be part of such hub, so that they also could be connected to such closed distribution systems and could be part of the balancing of the demand and supply in that area? So these are questions I think we also need to experiment with on the basis of these type of cases. And there are also ambiguities in the extent of the third-party access obligations that are applicable to energy hubs, and also to what extent should all users also really have the possibility to choose their own supplier, or is it possible that to make these hubs happen and to make sure that electric mobility from the city can really be integrated in the system of the hub and in the system of the city, that there are more possibilities to limit the free choice of supplier for certain important grounds. So I admit this is very complicated, stuff, and we all wrote this down in a report. So if you're interested, I can provide you with more background information.
Thank you so much, Saskia, and for this very interesting presentation. And now we will move on to our next presentation. If I can ask you, Saskia, to stop.
Oh yeah, I'm sorry, I look at.
That's fine.
Oh yeah.
It should be on top.
Yeah, I have it.
Many thanks. Thank you so much. So right now we are moving to our next presenter. It's Professor Martijn Groenleer, who is Professor of Public Governance at the Department of Public Law and Governance and Academic Director of the Tilburg Center for Regional Law and Governance at Tilburg University. Martijn, the floor is yours.
Thank you very much. You can see my screen, right? Full screen?
Yeah.
Yeah, okay. So you see here images of last night and of events you all have heard about. And this is usually how Europe, Brussels is portrayed in this extraordinary case. Obviously, the focus is on the member states, the Commission, the European Council. This is what you see. This is this room you see. Oftentimes, there's more than simple decision-making going on at the European level. And there is even more than agenda setting before the phase of decision-making. Oftentimes, it's actually much more about implementation in the European Union. However, this is still a very much an issue which is not put a lot of attention on This is why I am very interested in it. And I have come up with this very long title of my presentation, Implementation in the European Union, How Great Expectations in Brussels are dashed in The Hague, Madrid, or Warsaw, its capitals, but actually often in Appingedam, if you ever heard of it. It's in the north of the Netherlands, Ubeda, somewhere in Spain, or Prajnik, somewhere in Poland. Or why it's actually amazing that European laws and policies work at all. This is not a title I have entirely invented myself. It's actually based on the title of an existing book, a very famous book in public administration, political science, called Implementation by Pressman and Wildavsky, where they study implementation of legislation and policies in the US federal system. And while the short of it is implementation is not easy, and that's the same for the European Union, not so much a federal system, but definitely a multi-level governance system. And in fact, it appears to be exceedingly difficult, and that is something I will also focus on in my presentation. But I'll start with my window cleaner. I'm not living in Amsterdam anymore, but when I was living in Amsterdam, your windows are being cleaned without you being asked. At some point, there's someone cleaning your windows, telling you I'm your window cleaner. And at a certain stage, my window cleaner started quite out of the blue, started to complain to me about, he didn't know I was into politics or political science, public administration, but he started to complain to me about those strange rules from Brussels, and that it had to be over with all those strange rules from Brussels, which of course intrigued me. So I asked him, so what are you referring to? He said, like, well, yeah, so from Brussels, I cannot use my steps anymore on the left. It's too high. They have ruled that I have to buy this little truck there in order to clean your windows. I was living on the 4th floor. And yeah, obviously this is unfair. This puts me out of business. I cannot afford this. So it has to be over with all those strange rules from Brussels. Okay. Is it a justified complaint, right? Of course, in his perspective, it is. But the question is, who's Brussels here actually? I mean, member states, in this case, the Netherlands is very much part of the negotiations on these rules. So it's not merely the Commission or so. So it's very much also the member states. And do these rules really come from Brussels, right? It appears, especially in this case, that member states implement these rules and sometimes implement them in a much more strict manner. In fact, in this case, the height of these steps had been decided on by the Dutch Labor Inspectorate. It's not so much, there's no European Commission, or there's no European legislation that says that had ruled that my window cleaner was not allowed to use these steps anymore. So a lot of these rules actually do not come from Brussels, and there's, in fact, this shows the confusion there is about European legislation and the implementation of legislation, and the interwovenness in a way of legislation and implementation, and why it's important also to look at implementation. So what I will start with is a brief explanation of what I think it's about implementation in the EU, why it's apparently so difficult, and then 2 alternative endings, one for the optimists and one for the pessimists, depending a bit on which side you are. So I'll leave that up to you. But first of all, what am I talking about when I talk about implementation? So I use here a definition by 2 authors writing on implementation in the EU, but very much focusing on implementation in general also. The complex process of putting a policy into practice by a variety of mechanisms and procedures involving a wide and diverse range of actors, and especially the latter, keep that in mind. So it's much more than mere legal implementation, which is in the EU setting its transposition of EU directives into national legislation, and or making all kinds of implementation decisions, right? Ensuring implementation of legislation. So that's very much a legal process. I'm much more interested in practical implementation. So the actual enactment of policies, enforcement of laws, monitoring thereof through all kinds of measures, means, agencies, the courts, etc. And I'm not sure how familiar you're all with this, but just to make sure we're all on the same page, there is a formal division of tasks here. The European Commission, as you may know, is the guardian of the treaty, so it monitors transposition, whether it's done timely, completely, correctly, and this can be monitored, right? Relatively, it's not easy, but much easier than practical implementation. And if this is not the case, then it can start an infringement procedure with the court. The Commission also, in some cases, is invested with its own competences to implement. Competition policy is a good example, agriculture in a way. So these are the main tasks of the Commission. Then you have the member state that transpose laws, so legally, but also monitor, interpret through their courts, and not unimportantly, inspect and enforce rules nationally, also through national agencies, right? So such as the Dutch Labor Inspectorate that I mentioned, or environmental agencies, or food agencies, or well, there can be lots of different regulatory kinds of agencies involved. So an example, which is perhaps if you're a network focused on urban governance, a bit far off, but EU legislation on financial services. You may remember the financial crisis of 2007, 2008. And this is Barroso, the then Commission president, referring to the crisis exposing a gap in financial services supervision in Europe. The market was interdependent, so there was one market for financial services, but oversight was purely national. So what does this illustrate when it comes to implementation? And the challenges with implementation is, well, there was legislation in place, but even when but there were gaps. I mean, certain legislation was simply lacking. Okay, true, but even when there was legislation in place, the implementation thereof was an issue. So a lot of the regulatory regimes at the national level were very much oriented towards the national level, whereas this sector was very internationalized. And there were all kinds of expert committees put in place to help ensure coordination of implementation among the member states, but these didn't really function because there was, as soon as there were national interest involved, there was renationalization and there was no real coordination. So testifying to the implementation problem. Other example, EU legislation on water quality. You may know the EU Water Framework Directive. This is from the website of the World Wildlife Fund, referring to this legislation being unambitious and ineffective. So unambitious is very much about the goals of the legislation, so what has already been decided on, but ineffective is also very much referring to implementation, the lack of implementation or the delayed implementation on the ground. So you see that a lot of countries have actually made use of all kinds of exceptions possible as part of that legislation, as a result of which implementation is lagging, right? And some progress is made on water quality, but not as much as was expected, and perhaps not enough in order to reach goals in 2027. This is why implementation is important. I think it often is assumed that decision-making simply leads to practical implementation. But in fact, I think it's actually surprising that decisions are implemented at all in the EU. Why is that? And I want to refer to two challenges. One I will call the multi-actor setting. So clearly at the national level, implementation is already a challenge. So there's already multiple actors involved that have different values, interests, preferences. There's different arenas, but this is multiplied within the European Union. There's not only actors at the European level, there's national actors, there's not only the council, as I referred to, with the member states, but there's also the parliament, there's the commission involved. And that's only the European level. At the national level, you have parliaments as well. You have all kinds of executive actors involved, not to mention companies, citizens, right, that are involved, obviously, in implementation. So implementation, and this is a quote from a famous policy scholar. Implementation, especially also in the EU, is very much the continuation of politics by other means, kind of using the von Clausewitz quote about war being the continuation of politics by other means. So implementation is also politics, right? So this means that what perhaps was expected or hoped for at the decision-making stage, in order to reach that, is increasingly difficult due to that multi-actor setting. Another challenge being the multi-level setting. As you may know, there's this very strong culture of consensus and compromise at the European level among the member states. We've also seen that in negotiations in current crisis. That leads to decision-making and to decisions that not always all countries are entirely in favor of. And even if they accept them at the level of the member states in the council, doesn't necessarily mean that they're accepted at other levels, right? So what is decided on by ministries or prime minister or high-level civil servants is not necessarily something that is being accepted at lower levels, and especially not at the very local level, right? Which is hardly involved oftentimes in these kinds of procedures, even though they try to influence and lobby, etc. And sometimes indeed they are successful. So then at the local level, you find all kinds of cultures and traditions or other priorities or conflicting policy interests that actually interfere with decisions being made at the European level and that make implementation difficult. So, and this is whereas, so there's sometimes a lack of willingness, sometimes a lack of ability. So there's simply no capacity to follow through. This, whilst at the European level itself, the Commission or other entities have limited mandates or limited competences or capacity. So there's kind of like a mismatch there. So that leads to variation in implementation. Sometimes that's intentional, right? So because there's different, the countries differ, regions differ, cities differ, it makes sense to allow for some customizations, for some tailoring at the local regional level, for instance. So, and sometimes there's only policies adopted that apply to a subset of member states or not to all regions or cities in the same way. But oftentimes this is also unintentional. So there's even laws and there's the expectation of uniformization, but there's uneven implementation. So leading to an implementation deficit or regulatory gap or whatever you want to exactly call it. So then towards nearing the end here, two alternative endings. Depends a bit on how you look at the European Union. So if you're an optimist and if you're, or even a Europhile, how can these challenges be overcome? If you're a pessimist or fearful of European Union, it's about Europe's ever creeping, I call it, not so much Europe's ever evolving union. So how can challenges be overcome? Already in place are all kinds of committees, as I referred to in the case of financial services supervision, that try to harmonize, uniformize, coordinate implementation. They share best practices, etc. This is also known as comitology, but that is in a way only part, that is also part of the decision-making process. But there's also these committees when it comes to implementation. These are increasingly transformed in all kinds of networks of national authorities. And what we see also being created are independent EU agencies, right? In the area of the environment as well. You have a European Environment Agency that collects information, shares information. It's not involved in inspection though. So that's the kind of like the positive perspective on it. Well, the EU can create capacities itself, organize implementation capacity. So then a bit, perhaps if you would look at this from a bit more pessimist perspective, well, again, all kinds of competences delegated to EU institutions. So financial services supervision, for instance, the ECB has gained in power. It supervises the 60 biggest banks in Europe, or even new EU bodies have been created, European Securities and Markets Authority, for instance, that centralize in a way. In this case, not merely not decision making only, but also implementation and supervision and enforcement of EU laws and policies. Okay, so then to finalize, my 3 take-home messages would be: well, practical implementation is really different from legal implementation, and we oftentimes only talk about legal implementation. So really, it's about politics rather than mere execution. Secondly, multi-actor and multi-level setting in which the implementation takes place often leads to uneven practices across member states. Sometimes that's intentional and desired, but oftentimes that's also unintentional and unexpected and undesired. And in response to these challenges, we've seen more and more implementation capacity being created at the EU level. Some would say that's centralization. I would say it's a bit more nuanced. It's a bit more perhaps about federalization, like in the US system. Yet, I mean, it's undeniable that certain tasks and powers are increasingly also being dealt with at a more European level, whereas they still are dealt with also in the national setting. Okay, that's far.
Thank you very much for your presentation. And then we will move on to our next presentation and next speaker, who is Pauline Westerman, who is Professor of Philosophy of Law at the Department of Transboundary Legal Studies, Faculty of Law at the University of Groningen. And Pauline, the floor is yours.
Thank you, Jumek. You start. You
yes,
might.
And please let me know when it
okay.
comes the time to move on to the next slide. I'll share my screen.
So first, a word of caution. I'm a philosopher, and I noticed that when philosophers talk about law, they always refer to a very simple kind of examples, like no vehicles allowed in the park or something like that. And when I came to work here, where I'm now at the Academy for Legislation in The Hague, I found out that most of these rules were not so simple as that, as the philosophers would like to think. And that maybe the first slide, please, yeah. And that directives are a special form of, and I analyzed in the normative structure, so to speak, of this new kind of what I thought was a new kind of law, especially the directives. And I thought it is a good idea after of course, a couple of years, I found out that you might consider these directives as a normative embodiment of a process of outsourcing the law, so to speak, where you have a principle. It's you know, the economists like to talk about principles and agents, and where you have a principle who is setting an aim, for instance, like the proverbial visitor who is arriving at an airport in Lagos, Nigeria, and then he wants to hire a cab. And then he says to the cab driver, I would like to go to the hotel. So he's prescribing the aims, and then the cab driver is the agent who has, of course, the cab, but also the knowledge required to arrive at the destination. So this relation of principal and agent, I thought it was most useful in order to understand what was going on when we analyzed directives. What you see in a directive is not a prescription of aim, of means, like no vehicles allowed in the park, but it's more or less a direct prescription of goals, as was also clear at Martijn's speech. And then it is addressed to collective policy making actors. It's not addressed to the individual citizen, but to all those who are in the business of the aim involved. So if it is concerned with health, then of course all the actors are addressed that are somehow related or involved with health. It can be, in first place, the member states, of course, but also it can be all sorts of professional associations or insurance companies or whatever. So I'm talking in abstract about it, not about a particular directive, it's clear, but in the abstract, about the normative structure of these things. So when it is addressed, then in fact, a process of outsourcing is started, and that can be on different levels. So maybe we can see on the next slide, also again, a very sketchy analysis of the structure. And then you have always this prescription of aims that is listed under A, and I call them aspirational norms because I thought that would be a nice way of well, it's always very aspirational in the sense of, well, we should further something like marine diversity or responsible healthcare or whatever. And then the second element is always this implementation norm. And I completely agree with Martijn also that implementation is not merely implementation in sort of, legal implementation, but it is much more than that. It makes sure that you take the necessary precautions in order to achieve that aim. So it is not merely a sort of translation of a means norm. It is in fact addressing the norm addressees and telling them that they should devise their own means in order to achieve that prescribed goal, prescribed by the principle, so to speak. And then always the third element of this holy trinity, I called it in my book, the holy trinity of norms. And directive always consists of three elements, and the third element is a vital one. It is the requirement that you should report on what kind of progress you made as a norm addressee. So as that collective bunch of actors, they should report what they did, which measures they took, which policy documents they drafted, and which laws or rules they made. Now, you might expect that if it is issued from the European Union towards the member states, that, okay, the member states go and they implement what they are supposed to do. So you might, and in fact, half of the work is done in this way. But what I noticed then was strange, and I was really amazed by that, is that a lot of these directives are not directly implemented in this way, but they are somehow translated into a more concrete or more specified version of the same Holy Trinity. So the structure, the threefold structure of the directive is somehow preserved and reproduced at other levels. So then you see, for instance, that the member state itself is also making use of this tripartite division and says, well, okay, let's define a smaller goal. For instance, this is a very rude example, of course, in order to make it simple. A smaller goal, like the emission of toxics, should be as low as reasonably. So they define a smaller goal, a component part, and then they set of this sub-goal, this is the goal you should achieve. Again, they outsourced further rulemaking by saying, well, you should make a feasibility study, take the necessary measures, etc., including probably rulemaking. And then the final element, report on what you did, on the progress you made. Then if that is, for instance, issued to a steering group consisting of all those stakeholders involved in that goal, then that group is sometimes found to issue again to outsource further rulemaking by making the goal even more specific, should be reduced by 10% or whatever, and then say, well, okay, inquire into the best available techniques or whatever, and report on the progress you made. So what you see is a reproduction of this three-partite division, this holy trinity, as I called it, in which goals are issued, it is left to the norm addressee to devise the rules or the policies in order to achieve that goal, and then finally the accountability norm is added to that. And maybe we should see the next, because it's just short word on what these smaller goals look like. In fact, they are the result of two different processes. The first process is the concretization, because any non-addressee wants to know what effectively does this abstract norm consist in. If we are admonished to further something like a marine diversity or responsible healthcare, what does that consist in? So they first would like to identify the so-called themes or sub-goals, and they usually start to ask task force or committees or whatever in order to figure out what does this abstract goal consist in. And then they come, like, for instance, if it is responsible healthcare, one of my PhDs did a research on responsible healthcare, elderly care, and then they specify things like, oh, short waiting lists or adequate training facilities or whatever. So they define these sub-goals, so to speak, and which is the starting point for another outsourcing process, of course. But the second element that you should know is not only short waiting lists are part of the overall goal, but you also want to know, of course, what is enough? What is short enough? How short should the waiting list be? And that is, I think, the reasons of all these benchmarking committees and all these benchmarking activities, because then they usually start to specify the average performance of comparable actors who are in the same business. And then they say, well, this is about the average, what is performed or what is reached. And then they aim a little bit higher than that. And that is what you should specifically the aim that you should reach. So what you see already at the first level A of the previous sheet, the A in which the aspirational norms are formulated, you see that indeed, oh yeah, thank you very much, that indeed these aspirational norms in A1 and A2 are concretized and specified, so to speak, and that is the work of different groups to whom the process of implementation was outsourced. So indeed, implementation is much more than merely putting something into effect. It is a very creative thing, because they should, in fact, define the subgroups or sub-goals, the sub-components of the overall goal, and they should specify the amount of performance indicators or that specify what should be reached, the targets. So if we go to the next slide, Jan, then you see an enormous proliferation. If you see the concretization into themes and then the specification into performance indicators, you see an enormous proliferation and differentiation of the normative structure. Whereas, for instance, the classical norm, like no vehicles allowed, wanted to coordinate different aims, different goals into one simple rule. Here you have the other, exactly the different kind of thing. It is an enormous proliferation of rules, each specifying and concretizing the original goal that was specified in the overarching European directive. So yes, maybe it is not this window cleaner that Martijn spoke about. He was maybe right after all, that it is a Brussels thing, not because Brussels itself issued that specific rule, but because all the intermediate levels of specifying actors using the same kind of mechanism and the same kind of way of regulation, eventually came to this very specific and concrete rule that he had to deal with. Anyway, if you would put, the next slide, then you see that is also interesting, I thought. Not only the reproduction of the same regulatory or legislative mechanism, but that there is a parallel world of actors that is in the same way proliferating, because every principle then addresses an agent, but every agent in turn turns into a principle, outsourcing further rulemaking to other agents, and so on and so on. So in fact, every institution is tempted to adopt the attitude of the principle, outsourcing further rulemaking to others. And I think that is, we should take into account when we talk about this style, that it is not only about norms, as philosophers would like to think, or as lawyers would like to think, but that there's also, it has this parallel development of a proliferation of actors. So the enormous amount, for instance, of health and safety at work institutions can be accounted for when we see the necessity of defining the components of the goals and the performance indicators. Now, in short, the next slide would like to show you what are the, I just listed a couple of features of goal regulation, as I used to call it. So what is specific and which is remarkably different from the classical no vehicles allowed rule is that these rules prescribe desirable states of affairs. They don't mention the actions. They leave it to the norm agency to devise the actions that should be undertaken in order to achieve the states of affairs. They do not specify how the goal should be achieved. That they leave also to the agent to specify that. They also leave for at least most of them leave unspecified by whom the goal should be achieved. So it is in fact a sort of abstract, all those who are into this aim, they should, etc., etc. So it is no longer directed to an individual citizen or whatever. Then of course, that is the same as what I said before. There is an obligation of result. So it is not enough to say, well, I did my best to do this and that. No, you should establish and show results. And this is important, of course, in this, this duty to report, the third element of the directive, because at each level, the agents should show to their principal that indeed they did their best, or that indeed they took measures, or they took policies, or they devised rules or whatever in order to achieve that goal. So everybody who is working at the university knows that you should in your self-report constantly engage with what is required by a certain format and say, well, indeed, we did develop a test protocol in the sense that, or indeed, we came up with a new mechanism in order to further integrity or whatever. We had an ombudsman here, or so you should show results. And that means that you are also liable for not reaching that result, that it is also, of course, inherently connected. And that means also a reversal of the burden of proof. It's not enough that there are no calamities, or that everything, it's not enough that nothing terrible is happening, but you should every 2 years or whatever, you should show to monitoring agencies or to peers or whatever, that indeed you took measures in order to achieve a certain state of affairs or goal. And because these goals are usually positive, it is not all of them. You can say, well, we should reduce this or that, but usually they're formulated in positive terms. Then, of course, you have always this need for specification. And I think that is one of the reasons that is accountable for this enormous proliferation of goals. So I would like to go to the last sheet. Just to enhance the discussion, probably, I think that of course it makes such a directive makes use of local knowledge, and that was indeed the inspiration for that kind of directives, because they couldn't govern all the European member states in the same way. So you had to make use of local knowledge, but that implies that there is no level, not sometimes a difficulty of finding a good level of coordination where all the different goals are coordinated. It gives the freedom of choice about the means that can be used. Explicitly, they say, well, as long as you have reached this state of affairs, then you are free to devise your own means. But of course, that means that there is no freedom of choice about the ends to be pursued. Well, in fact, I have to qualify a little bit, because of course you are able to define the sub goals in the way that you have a certain freedom in defining the sub goals as a sort of committee or whatever. But that is about it. So it is not about how to balance the different goals or how to coordinate the different goals. That is something that tends to be underrated, and that is the reason why people complain about contradictory rules. It is not because the rules are contradictory, but they're not optimally balanced with each other, so to speak. Then, of course, you can say, well, it's a very good idea that we draw in all the nurses and all the people who are actually teaching into this rulemaking process, and that is one of the rhetoric that was used in order to advocate this strategy. But we have to be aware that, of course, most of the, especially this duty to report, enhanced the necessity and the need for managers that compiled all the information and did this reporting job. I would be in a terrible state if I, as a university professor, I had to do all this collecting and assembling of all these results myself. So I'm very glad that there is an office who is doing this kind of thing. But that means, of course, that the individual professional is always encountering this intermediate layers of managers rather than that he is doing his own kind of rulemaking. So we have to qualify this ideal as well. Then fourth, I think it's important that if we are talking from The Hague, as I'm doing now with all these legislative drafters here, they might think that, we are deregulating, we are, of course, making legislation much more simple, because they can show that, for instance, they reduced an enormous amount of rules into only one sheet saying, well, you should further responsible healthcare. So, for instance, I remember that someone a couple of years ago walked in here and said, well, I was so successful, I got rid of 500 rules pertaining to hospitals and I put it into one A4 sheet. Of course, at the central level, it is you can see that there are less rules issued, but of course, the overregulation take place in other more local levels. They have to find out what the components part are. They have to determine the threshold levels, etc., and the performance indicators. So what is done now is that for instance, all these smaller groups, committees, and managers are doing that kind of work. So, and that is somehow completely overlooked in The Hague. It is indeed an efficient way to achieve certain goals, maybe efficient, I'm not completely sure. But on the other hand, for the agents, it's not so efficient. And we all know the complaints about, oh, I have to make so many reports, I have to make so many for instance, pupils' progress on the pupils at schools, etc., at all levels. I think that because of the fact that this style, this tripartite divisions, this style is reproduced at all the local levels as well, and somehow percolates into the finer tissue of the society. Everybody is at one point either reporting or monitoring, so to speak. So we should keep that in mind as well. Flexibility is the last big ideal of this form of regulation. And yes, indeed, we can have, but it was also said before, we can have a lot of flexibility, but that also means that there is a certain loss of legal certainty, and that local differences can be more important, and not only local, but also in different sectors can be, it's also rather problematic. So with this provisional balance, I just want to stimulate discussion. Of course, other people may be more optimistic. I don't know, and I'm really looking forward to the discussion. And thank you for your attention.
Thank you very much for your presentation. And now that we've gone through all 3 presentations, now is the discussion time. And then for this, we are inviting Assistant Professor Tobias Arnoldussen, who is Assistant Professor of Public Law and Governance at Tilburg University. And Tobias, the floor is yours.
Thank you very much, Gumech. And well, let me start off by saying how recognizable it is, Professor Westerman, to see myself in this link of reporting, because I've just this morning been asked to submit a whole host of documents to the testing commission so they can review whether the test that I gave, Introduction to Law, is actually up to the task. And yesterday I asked my students for the evaluation, and I also give them back their grades. So basically I'm also a link in a continuous chain of reporting. And in any case, thank you all 3 for your presentations. It gave a great overview of how directives work on ground level in the concrete case that Professor Lavrijssen showed us of the Rotterdam Metro, between EU institutions and member states, the question of implementation that Professor Groenleer addresses, and the very nature of these directives as Professor Westerman showed us. And it reminded me of an interesting research that has been done among the people of the Netherlands some time ago already, that concluded that people love the Constitution and consider it important, but have no idea what it actually says. And I wonder what would happen if you would conduct this research with European directives. I guess many do not know what they actually say, but I do not think they are very well loved either. And Professor Groenleer's example also confirmed that. And I wonder if people consider them important. And for many policy fields, the environment, for instance, Europeanization is actually the norm, right? Most Dutch environmental rules are a product of European directives, and they have large implications for our legal order. Even the conflicts that play out in society are to a large extent results of European directives and their implementation. For instance, the problem that we have with nitrogen emissions and the anger of the Dutch farmers can be traced back to a European directive, the so-called Habitat Directives, and its rules. So they are crucially important, but their importance is little realized. And it might indeed be because the legislative game in Europe is not very transparent, as Professor Groenleer showed us. It involves a lot of institutions, also little known publicly, and they represent a diversity of interests. These many actors are involved, and they show a very complex process. And well, that might well lead to the public also disengaging from them. And this whole European process even takes place before the implementation phase, right? So generally, the public does not even notice that this or that rule is the result of a European directive, except when things go wrong and politicians start blaming Brussels. The window cleaner learned that this was a Brussels product because he was told to by national politicians who actually blamed Brussels for what might have been gone wrong in implementation. So unknown, unloved, but important. That might be the conclusion of European directives. And the question is, are they only important because they determine the policy of the member states in the respective area, or is more at stake? Due to this idiosyncratic process of policy making in the European Union, this leads to compromise regulations, right? Because the institution and member states influence what the laws are, and they have to make compromises among these host of institutions available in it. So rarely does an important proposal for a directive find favor among all member states, so they are the result of balancing acts between European goals and member state autonomy. In a way, they are the result of wanting to have your cake and eat it too, because they try to do both. They try to keep member state autonomous and give them a large say in actual implementation, but also reach a certain goal. And that entails a different kind of rulemaking, as Professor Westerman's research displayed. Behavioral norms give way to aspirational norms. Instead of regulating behavior directly, we resort to setting goals, and the expected behavior among the people will be laid down by the respective member states and will be further outsourced. Now, as I read it, Professor Westerman's provocative thesis is that European directives have in large part changed the face of law, of what law does and how it functions. That's a very significant development, I think, because our legal order reflects who we are, right? Law is a product of societal relations and reflects how they are characterized, and it also reinforces certain characterizations. So there are interesting questions to be asked here. How does such a change in the fabric of law reflects on our society? What does it say about our society? For instance, as Professor Lavrijssen told us, the European Electricity Directive does not create any hurdles. The interesting thing may be that the European Directive itself is not meant to create any hurdles. Is it meant to create hurdles in the sense of prohibiting behavior, or does it lay down a certain goal that it wants to reach, and a certain implementation norm and a certain strategy demanding that we have certain structures in place for a company, but it allows member states themselves to make all kinds of exemptions to regulate those companies. So it allows for flexibility and leaves open changes in function. It seems to me that the regulations do not regulate behavior itself, but try to create a certain market, namely the market for many different suppliers of energy. So my hunch would be, but I'm not sure if I'm right, my hunch would be that the directive prefers free choice, and that it prefers a diversification of energy companies. But maybe Professor Lavrijssen could enlighten us further. It also seems to reflect the situation that actors are not fit into a certain role anymore, which used to be the case. Boundaries are increasingly blurred. A public transport company can also play the role of an electricity company. Behavioral norms might then be very inefficient. Would it not be a good idea to make law more flexible in that sense, goal-oriented, and therefore more adaptive to the different choices that actors make and the blurring of the boundaries of what they are doing in practice? So I wonder whether it may be necessary to refer to such a new mode of lawmaking. Is it necessary to make European rules work, as Professor Groenleer asked? Because the question is, well, it's actually rather strange that they work at all. Well, is it maybe possible that they work at all because they have this different structure about them? On the other hand, I wonder what this kind of lawmaking does for responsibility. A traditional norm, when it is transgressed, we can hold the person transgressing it accountable. But when something goes wrong in the whole process of this outsourced law, if you make it, diffuse it over different actors, who can we hold to account? If is a misfit between a European rule and a member state's legal order the fault of European institutions who drafted the wrong directive? Or is it the fault of the implementation of the directive? Or is it the fault on a lower level, which created a more stringent goal which couldn't be realized, for instance? So does an aspirational norm itself also invites an outsourcing of responsibility? As law concretizes, different actors become responsible for different parts along the way, but no one for the whole anymore. So that would be a question I would have. And finally, a rather personal question because of my own interest and because I'm sitting here, I feel I can ask it. And because we have been talking about the Omgevingswet, the Environment and Planning Act, in all three of the seminars so far. So I do not want to leave it out now, because I wonder to what extent is the Environment and Planning Act, to what extent do the panelists see this act as a product of this Europeanized environment, or as an example of outsourced law, as Pauline Westerman showed us? I will leave it at that, and I'm really curious about the answers. And thank you again for this, for 3 lovely presentations. I really enjoyed it.
So who is about to answer first?
Well, I would say whoever feels.
Okay, well, I can be very short about the Omgevingswet, at least, because I think that's a clear example of outsourcing the law, of course, because then you start to say, okay, at the local level, they will coordinate the different sectors, they will coordinate the different aims. And so you outsourced it there. And I think that is the major drawback of that law. The first question, you say, who is responsible in that outsourced regulatory landscape? I think that, well, I had a short chapter, it was not the best one, I think, in my book, on the position of the judge, the courts, what can they do in this outsourced landscape? And you see that they are increasingly impotent, so to speak, in order to address this, because they have to do with all these intermediate supervisory bodies and so on, and they implemented the directive, and they said, okay, yeah, well, we have made further rulemaking, and then the judge says, yeah, I don't want to trespass on the discretionary powers of these rulemakers, because there's so many mini legislators now going on, and if they want to have their to confine themselves to their proper trade as judge, they are reluctant to trespass on these discretionary intermediate forms of rulemaking, which weakens, I think, the position of the individual citizen who is vulnerable to any adverse effects of these rules or any gaps in that rulemaking. As for instance, in this, I had this example of, I think, medical equipment, which was then, of course, the supervisory board had said okay, had this whole procedure, and then the individual citizen was left with no redress. So yes, I think that your intuition is right there.
Tobias, I would like to give you a compliment that how you formulate your response on the spot. Very elaborate, so you're good at this. I was thinking about the Omgevingswet. I think it's there. It's also because of national and European developments that there is more and more an understanding that some flexibility is needed to implement laws at the local regional level, and that support from the citizens and consumers is needed to do that in a way that there is societal support for policy. So I think that is also an important base of this whole new legislative operation. I think that EU law does not provide any hard laws on how to design your planning procedures and your participation procedures at the regional local level. So I think that's an interaction between national and EU developments, but I'm not an expert in the Omgevingswet.
Me neither.
Yeah.
Well, it was just it was more of an example of a current law.
Yeah.
Are
you an expert in the Omgevingswet?
I wouldn't call myself an expert, but I'm very interested in the Omgeving.
Okay, but it's good to know that there is a colleague here at Tilburg who has that interest.
Maybe I can add, and then maybe ending up with the Omgevingswet. Something I didn't really include, but that is also the character of the experimentalist nature in a way of how legislation and policies are being made and implemented at the EU level, even when it comes to areas where the EU level as such has quite a bit of competences. The fact that the whole setting is more like a network type of setting than a hierarchical setting requires the kind of legislation and policies that leave room for maneuver, flexibility, etc., in order to get acceptance also from the member state level and even lower levels when it comes to implementation. That at the same time then leads to all kinds of issues when it comes to actual implementation and actual following through on certain rules being made at the EU level. So the whole issue of the balancing between that level of flexibility and room for maneuver with some level of bindingness and some level of accountability in a way. Indeed, so that is what I see also as a challenge when it comes to the omgevingswet. I mean, leaving all that room for maneuver and also for experimentation and learning, etc., in a rather what is portrayed at least as a network kind of setting, and the level of bindingness or at the very least coordination that's also necessary, especially when it comes to spatial problems and spatial issues, right? So that's something I hadn't introduced as of yet, but that I was also thinking about. That is in a way implicit in my presentation, that the nature of the EU setting is different from the nature of the national or the domestic setting. Which has an impact on the type of rules and legislation, and has an impact on implementation in a way.
Thank you very much. And Tobias, is there anything else you would like to add?
No, not at all. And I would also like the audience to give the floor to the audience, because they must also have been burning with questions.
Yeah, we have a few questions, but thank you so much before we move on to them for this discussion, and also thank you to speakers for their answers to Tobias' questions. And we unfortunately don't really have much time to go through all the questions, but I'm gonna pick a few from the chat box. And there is one question to Saskia, is from Ebru Kurt-Özman. If I understood it correctly, you are quite positive about the ability of European directives to steer innovation concerning local energy grids. But could European directives do more to make sure that local energy grids succeed?
Yes, I think they can stimulate innovation, but also limit innovation. So when the European market was redesigned in 1990, then it was assumed that the local grid operators have monopolies. So the distribution system operators all have monopolies. And there was an exemption for the closed distribution systems, and these rules are quite strict. So innovation beyond the scope there of EU law is not really possible, because EU law says there, no, in principle, we have the monopoly of the system operators, and the closed distribution system operators are just an exception to that. And if other parties want to create their own local grids in a smart way, actually EU law that now hampers this. And the question is, how can we overcome this limit of EU law? I think that takes quite a lot of examples and some input to the Commission to show that things need to change, because the whole market changed, the technologies changed. We will have home batteries within 10 years. So everything changes. So is that what how the market was 20 years ago, is that still a good base for regulating the way it is now? So there it limits, but on the other hand, it's also tries to stimulate innovation. That is by facilitating prosumers and energy collectives and stimulating the rollout of smart meters. So there it stimulates the member states. And it also, the EU approach of regulating the energy market is more a principle-based approach, looking at goals, whereas in the Netherlands, we usually have more a rule-based approach of regulating the energy market. So that limits innovation. So here you see that EU law has more leeway for innovation than that we do at the national level. And gradually we have to adapt the approach in the national level to make sure that our laws are compliant with EU law. So it's not a black and white story, I think. And the EU law also tends to give a lot of leeway to national agencies, to independent regulators, but at the same time, it's coordinating them in the EU agency that has to adopt European regulations that regulate the acts of the agencies again. So there you see, it's not that simple. And also I would like to point out, and I also heard you all talk about it, is that there are a lot of coordination mechanisms and they make use of a lot of informal acts. And then that really affects also the position of network users, of consumers, because if there are certain choices made in these acts, they cannot go to the judge because those are not legal acts, but informal acts, but they can still have a lot of impact on decisions. So there is also, I think on the one hand, this coordination is good, but on the other hand, it also has very, it has rule of law implications also.
Thank
That's
you.
Yeah.
Thank you very much for your answer. And unfortunately, we don't have any more time for the questions, but let me just say this has been a really interesting session, especially also, I believe, for people such as myself who don't know much about the European directives. But I guess we will be able to use a lot of insights from this session for our own research that is related to policy and law. And before we conclude our session, I just would like to ask our participants to wrap up what they can take from this session. What they learn about from this session, and perhaps we can start with in the same order. If Saskia, if you would like to answer that, conclude with a one sentence. What was your take from this session?
Well, my take is that that the directives are very complicated instruments, and that you see that indeed law is not the only aspect, but you have to look at the factors that are important for implementing these laws, and that coordination can help to give more certainty to certain actors that have to work with EU law, but on the other hand, for other actors, it can become very confusing and they don't understand anymore where the laws come from or the rules come from. Yeah.
Thank you very much. Martijn?
Oh, difficult one. No, I always learned from philosophers because they reflect on what seems to be or common or is taken for granted in a way. The fact that we have these directives and the way they operate. So kind of like here delving into that is very valuable. I think that should be done more also. By practitioners and at the European level, not merely taking for granted that we have these things and how they should operate, but looking into what is all behind it and how that has an impact on how they may operate. I also learned from Saskia's presentation about how this at the ground, and when you want to innovate, how this at the ground level, what the impacts thereof are. So I learned in that sense how it very concretely manifests at the local level and how it indeed limits at the same time enables, and that it also in the end depends a lot on actors at the various levels that can either or not act strategically, cleverly, smartly in which may also put at other actors more vulnerable actors perhaps that are less able to maneuver, to navigate this complex situation. So that they may put actually be put at a distance or may lag behind in a way.
Thank you very much. And Pauline?
Yeah, well, to be honest, I come from Rotterdam, and I know as a child RET, which was of course the bus and tram company, and I did not know at all that there was the possibility of acting as a microgrid or whatever. I didn't know that it was possible. So this was all very new. I mean, I don't know anything about it, and I was baffled by this. I mean, yeah. So thank you, Saskia. Then of course, with Martijn was a little bit more familiar to me. And I think that sort of helped me to realize once again that maybe I should be more attentive to the fact that we should not conceive these principal agents in simple hierarchical terms, but in more central, decentral. That is more accurate or more appropriate way of doing this. And I'm now dealing with international law rather than domestic administrative law. And I think it's interesting to see because, of course, it's not only the European Directive which is the starting point, as I said, but it's an international affair as well, where all the where rules tend to become to be formulated more in this format than so, and then you have to do not with hierarchical, but indeed with networks with a longer or shorter distances to the center, so to speak. So that was reminded once again by Mama, if I understood him correctly.
Thank you very much. And Tobias?
Yeah, thank you all. I learned a lot in any case, but what really sticks to my mind is, Pauline Westerman in a side sentence said, well, we're all becoming little legislators ourselves, more or less.
Officials.
Sorry?
I said in my book, we are all becoming officials, either legislating or controlling others.
Yeah, we're becoming micro officials, micro legislators, but we're also becoming micro energy companies, right? So like the RET is, but now we will have home batteries, we'll become micro energy, we will become micro everything. We will become micro complicit in all the structures that guide us. So the traditional idea of law is that I'm a subject of law, and if I behave like I should be behaving, then I'm basically, I just have to have responsibility of my own affairs. But when we become micro everythings, then we can also be called to the task about everything. That is a bit of a scary thought to me.
Yeah. Rights also means responsibility.
Yes. which is an interesting development area.
Yeah, but you're responsible for having brought about a state of affairs. You're not responsible for your actions.
No.
But you have to see to it that a certain state of affairs is brought about, either by yourself, but usually by others.
And I will have to report on whether the state of affairs has been brought about. So that will be my takeaway.
Yeah. Oh, Gumek, you're...
I'm muted. Thank you very much for reminding me. And thank you so much to all of our participants. It was such a lovely meeting. Unfortunately, we had to stop. Otherwise, I'm sure people like me, we really wanted to ask you more questions, but we needed to end it here. And let me just briefly present our next webinar series episode, which will be held on the 10th of March. We're going to talk about law and policy issues with regards to urban regeneration projects. And before we conclude, I would like to wish you all a good afternoon. And if our participants can refer to their email inboxes, you will find a link for a short recap session. This is just to offer our thanks if you have time. And we will meet you shortly in another session. Thank you very much and goodbye.